Bam! Welcome, everybody. Welcome to this episode of The Branca Show. I am, of course, attorney Andrew Branca, and we are here to talk again about Dalton Eatherly, Chud the Builder, and how his claim of self-defense just keeps getting stronger. And the prosecution's case for guilt just keeps getting weaker every single day. We had a court appearance yesterday over bail and some other matters, and new evidence was revealed in that court hearing that only strengthens the self-defense claim of Dalton, Chud the Builder, Eatherly in the shooting of Joshua Fox, while increasingly making it clear that it was Fox who was the unlawful deadly force aggressor in violently attacking Dalton Eatherly. Indeed, now a full 9 days after the May 13th attack by Joshua Fox on Dalton Eatherly, Joshua Fox, a black man, Dalton Eatherly, a white man, every one of the most feared vulnerabilities, the things I was most concerned about for Eatherly's claim of self-defense, are resolving in Eatherly's favor. And the evidence of Fox as an enraged, deadly force aggressor of an innocent, retreating Dalton Eatherly only grows greater. It's unbelievable. It's unbelievable. It's another Zimmerman case. It's another Rittenhouse case. I had much the same experience when I was covering the George Zimmerman trial. When it was in the news before the trial started, I got a hold of the evidence file, the discovery file, and I was looking through these thousands of files, photographs, reports, video, forensics evidence. I kept looking every day. I said, well, surely George Zimmerman's claiming self-defense for shooting Trayvon Martin. Surely there's evidence in here that's inconsistent with self-defense. The state has charged George Zimmerman with second-degree malice murder. They know they have to disprove self-defense beyond any reasonable doubt. Where's their evidence? And I couldn't find any evidence in the discovery file that was inconsistent with lawful self-defense. Nothing. And then the trial starts, and I'm watching it. I'm live streaming the trial, and I'm thinking to myself, this will be the day. This will be the day, surely, when the state introduces evidence before the jury that's inconsistent with self-defense. And day by day by day went by, and it never happened. It never happened. And then people wonder why George Zimmerman was unanimously acquitted by a jury consisting mostly of women and minorities. If you think the state will not bring a prosecution based on nothing but political fervor, you didn't watch the Zimmerman trial. You didn't watch the Rittenhouse trial. And that sure looks like what's happening here as well. Based on the evidence we have in hand, and based on what the state is not saying and not sharing, the dog that did not bark in the night. Very revealing. Now, could the evidence change? Sure, of course. If the evidence changes, the legal analysis changes. But based on the evidence we have, and that's emerging, and what the state is hiding from us, I see self-defense only getting stronger for Dalton Eatherly. Now, I caution, I'm getting a lot of you are sending me very kind words on social media, particularly on X. I love your coverage of this. Go Dalton. Listen, folks, I only follow the evidence. If bad evidence develops for Dalton Eatherly, you're going to hear about that from me too. And if that changes the analysis, my analysis in a negative direction for self-defense, that's the way it goes, folks. I can only call them as I see them. But based on what I see so far, this is a very strong case of self-defense for Dalton Eatherly. So let's go through a couple things here. We had a bond hearing yesterday. Let me pull this up. This account, by the way, Archetype Theory has been doing great work on this from the beginning, so I would urge you to give him a follow on social media. So he reports yesterday the judge lowered, and I have the video of the bond hearing, by the way. It's about 5 minutes long, so we're going to watch the whole video. So make sure you hang with me. Yesterday, the judge lowered Dalton Eatherly's bond from $1.25 million to $1 million. That is still higher than every single murder defendant in Montgomery County under this current district attorney, Robert Nash. He recounts archetype theory, recounts a man who confessed to raping and murdering a 9-month-old baby got $100,000 bail. A man with 4 separate murder cases across 3 years, $2,500. A man arrested on new felony charges while already out on bond for first-degree murder got $100,000 bond. A convicted felon who committed a double murder, $750,000 bond. There's a graphical representation of this that he did that I really like. I mean, these are murderers, grapers, multiple murderers. People actually died. They murdered them. Dalton Eatherly did not kill Joshua Fox. It was an attempted murder, not a murder. And look at the disparity in bond here. It's quite remarkable. Look, I'll zoom in here on this if I can. Let me see. There we go. Look at these. Here's an attempted murder one, and combined with a robbery, which is not a charge against Dalton Eatherly, $10,000. $10,000. Let me skip here. Here's a comp. Attempted murder, weapons charge, aggravated assault. That's comparable to the charges against Dalton Eatherly. How much was the bail? $50,000. 1/25th the bail being charged to Dalton Eatherly. And by the way, don't say it's because he had this give, send, go money. This was the bond set before there was any give, send, go money collected. Whitney Brown, first-degree murder. She would end up convicted. An aggravated child abuse, infant murder, $50,000 bond. Angela Brown, second-degree murder, $100,000. Zachary Clark, second-degree murder, $250,000. And this red bar, of course, is Dalton Eatherly. Dalton Eatherly. All right, I have the bond hearing here. And again, it's only about 5 minutes long, so we're going to watch it together. Before I do that, a little bit of housekeeping, because I want to mention to all of you, my good friends over at Chapter Medicare Advisors. If you're on Medicare or you see Medicare coming, it's getting close to your time to choose a plan for Medicare. You want the right plan for you, the one that's best aligned with your healthcare needs and at the lowest cost. The typical Medicare brokers out there who sell you these plans, they have no fiduciary duty to sell you the best plan at the lowest cost. In fact, they have every legal privilege to only offer you the plans that give them the biggest commission. And of course, that commission has to be paid for by a more costly plan. Don't get suckered. Make sure you're getting the best deal for yourself, or if you have a loved one on Medicare. Historically, Chapter has saved its members thousands and thousands of dollars on Medicare costs. And they're the only organization that covers all 24,000 Medicare plans out there. Give them a call. They're very friendly. You won't get a high-pressure sales effort from them. If you have what's best for you, they'll tell you you're all set. And if you don't, they'll offer you options that are better for you at lower cost. And it's free. They don't charge you a penny. So give them a call at 617-644-0093, 617-644-0093. If you want to, tell them I sent you. You don't have to, but they know me. They're friends of mine. 617-644-0093. All right, let's jump into this bond hearing. This, of course, is the judge. The judge is kind of interesting, actually. He's had a little bit, not a lot, but a little bit of disciplinary interactions with the Tennessee bar when he was an attorney, not as a judge. It happened before he was an attorney. His name is Poland. Hugh Reed Poland the third. A long family line of Hugh Reed Polands, I guess. maybe we'll touch on that later. It's not really relevant to the case in particular, but it's in the news. In any case, here's the judge. Obviously, he likes a good table, and we're going to start the hearing right here. Let's see. You know what? Let me just make sure I have the echo turned off. Here we go.
Anybody that caused any kind of disturbance at all is subject to being in direct contempt and serving 10 days in jail and a $50 fine or both. I just want you to know that. We're not going to put up with any outbursts or any shenanigans today. Okay? Any questions? Okay. What do we got? State versus Dalton and Eatherly. I'll bring Mr. Eatherly out.
There he is. The man, the myth.
Good morning, Mr. Eatherly.
The defendant.
This is you're here this morning, case number 26 CR 5295. You're charged in count 1 of criminal homicide, 39-13-201. That's an A felony. It's punishable by 15 to 60 years in state penitentiary. Count 2 is deployment of firearm during a dangerous felony, 39-17-13-24. That's a D felony. Normally, that range of punishment would be 2 to 4 years in state penitentiary. However, by statute, this case is a charge is enhanced, and if you don't have any prior convictions, it's a mandatory 6-year sentence at 100%. Count 3 is ag assault with serious bodily harm, 39-13-102. It's a C felony. It carries a range of punishment 3 to 15 years in state penitentiary. Count 4 is reckless endangerment with a deadly weapon, also a C felony, 3 to 15 years in state penitentiary. Have you hired an attorney yet, sir?
Yes, sir.
You have?
Well, I have Jake Finley.
Okay, Mr. Finley's here. You've been hired yet, Mr. Finley? I know you have a prior relationship with him in other cases.
No money has changed
No.
hands.
All right.
Just
So
spots.
I'm going to appoint Mr. Finley right now.
Well, that's interesting. No money has changed hands. Jake Fendley, who I had a little chat with yesterday, by the way, Dalton's attorney, very informal, just 2 or 3 minutes. Hey, I'm Andrew Branca. This is what I do. And, he's an attorney in Tennessee. That's what he does. We left off agreeing to have a more substantive conversation soon. But just full disclosure, I have had a chat. I'm not part of this legal team or anything like that. Just had a very informal chat with Jake Fendley.
To represent you, should you make your bond and you want to hire if you make bond, you're going to need to probably hire Mr. Finley. I'm going to set this for preliminary hearing on the 26th of May. All right, that'll be inside the 14 days, Mr. Finley.
May 26th.
Does that work for your calendar?
I can double check, Judge.
Yes, sir.
Is bail set?
Not yet. I'm about to do that. I want to make sure he's got an attorney and all that stuff first.
Yes, sir. May 26th.
Okay. All right, bond. Bond's not been set yet. General, do you have a position on bond today?
Oh, is this the first one? This is not yesterday's? Oh, sorry about that. Sorry, I thought this was yesterday's hearing. All right, we have news reports of yesterday's hearing. So let's go ahead and summarize what happened there. So bail was reduced from 1.25 to $1 million, still $1 million. Key issue there. It's too bad we don't actually have the hearing because there was stuff. Well, we'll rely on the media reports of what happened, unfortunately. Bail was reduced to $1 million. But the judge also wants what's called a source hearing. Now, there is a company putting up the bail money, reportedly. We'll cover that in just a minute. But despite the money being offered for Dalton, the judge wants a source hearing. What's a source hearing? Well, if the defendant says, I can put up the bail money, the prosecution's allowed to say, well, we got to make sure that bail money is from a legitimate source. For example, if someone is charged with robbing a bank, and they ran off with a bunch of the bank's money, you don't want them to be able to use the bank's money to make bail. If they're a drug dealer and they have millions of dollars for the sale of drugs, you don't want them to be able to use the illicitly gained drug sales revenue for their bond money. So under Tennessee law, this is true in many states. If tasked, the prosecution can say, hey, you have to show the court that the source of these funds you're using for bail are not illicit, that they're legitimate. And that's what the state asked for here, and the judge is going to have a source hearing. Now, give, send, go money is not illicit. There's no problem with using that, but the hearing will have to be held. And as it happens, it looks like there's a private company that's going to put up most or all of this bail money for Dalton, in which case that's legitimate too. They're a legitimate organization. They're not a criminal enterprise, as we'll see. Also notable, the judge put a gag order on Dalton. He's not allowed to go on social media and say anything about this case. The facts of the case, directly or indirectly, nothing to do with the case. Why? I mean, it's not a good idea for him to be talking about it anyway. It's interesting, right? No gag order in the state that I'm aware of. So this is the news. Polymarket reports that an anonymous donor reportedly offers to pay Chud the Builder's $1 million bond. And that anonymous donor is reportedly Duel.com. I believe it's Duel.com. This guy, Paul Miller, writes, my sponsor, Duel, is actively trying to bail Chud out. They have the $1 million ready to go. They're just waiting for payment instructions through their lawyers. I can't put into words how grateful I will be if they can make this happen. I'm very proud to work with Duel. And what is Duel? Duel appears to be a gambling website. I don't mean that in any negative connotation. I don't gamble myself, so I'm not personally familiar with Duel. But this is their website, a little profanity. And I guess they have a bunch of games that you can legally gamble on. And they're willing to put up the money. So here's Taylor Hansen, an independent journalist, I believe. He says, now that it's public, I can confirm that the popular gambling website Duel will be posting Dalton Eatherly's $1 million bail. Amiri King, who's been following this case and commenting on this case closely, and has a little personal experience with the criminal justice system, as he's happy to share himself, writes that, well, they don't have the money yet. They need someone to show up to court and give a statement. They can't, for some reason, currently working on this. That statement is the source hearing. They just have to appear before the judge, or their lawyer will appear before the judge and simply attest that these funds are from a legitimate source. It shouldn't be any difficulty. As this account notes, there'll be a source hearing, and the judge will almost certainly rule that Chud the Builder can use fundraising money to bond out, assuming he could come up with all of it, and now it looks like Duel is going to use it up. So whether it's give, send, go, whether it's Duel, as long as the funds are not illegal or fraudulently acquired, they'll be able to use them. We already talked about how remarkably high the bond is for Dalton Eatherly compared to other people who've committed similar or worse crimes. We also have some accumulating information about Joshua Fox. Joshua Fox, the person who attacked Dalton Eatherly and got shot for his efforts. Joshua Love apparently has been looking to confront Dalton Eatherly for some time. This is a number of his posts online, January 10th. I've been hoping to run into the Chud MF, but he don't be on this side of town. People telling him to calm down. Joshua, he goes by Joshua Love, but his actual last name is Joshua Fox. Trying to get some traction on my end, so when I start my Twitch, I got a little fan base. I just want to fight. Now, why would this be relevant? Well, it's relevant in a couple contexts. From Dalton's perspective, it's evidence of who was more likely to be the initial aggressor in this confrontation. Also, Joshua Love is likely to have to take the witness stand. He's the victim. The victim, that's what the legal term would be here, legal term of art. He's the victim of Dalton Eatherly's use of force. And if the state doesn't call him as a witness, the defense will certainly call him as a witness. And then once he's a witness on the stand, his credibility and character are subject to examination just like any other witness. Now, he could potentially not take the stand. It would be interesting if Joshua Fox made the decision to inform the court that if he's put on the stand, he's going to simply plead the Fifth Amendment and not answer any questions. He'd be allowed to do that. In fact, if he tells the court that ahead of time, the judge will probably not allow him to be put on the stand, even by the defense. That happened in the Derek Chauvin trial, by the way. Many people don't know this. If you didn't watch the trial, you may not know. But while George Floyd was overdosing to death through this entire interaction where he fought police for 10 minutes after a counterfeit bill, swallowed the drugs he had in his car, there's chunks of tablets in his mouth the entire time he's fighting off 4 police officers for 10 minutes, with existing cardiovascular disease, a 3 times fatal level of fentanyl in his bloodstream, meth in his bloodstream, you know the whole deal. While all this is happening with George Floyd standing on the sidewalk, shockingly, is a dude who's George Floyd's drug dealer. George Floyd's drug dealer is right there. Maybe that's why George Floyd had all those pills in his mouth. Maybe he just made a transaction. George Floyd's drug dealer was standing right there, was a witness to what was happening. And he was called, or he was going to be called, as a witness by the defense. But George Floyd's drug dealer told the court, listen, if you put me on the stand, I'm just going to plead the Fifth. So that didn't happen. There's no point, right? He was on the stand for a little bit, but it was an outside the hearing of the jury attestation to the trial judge in that case. So that would be interesting, and especially how the jury might perceive Joshua Fox not appearing as a witness because he took the Fifth Amendment. Where's the victim here? Let's see. Now, of course, Dalton Eatherly, Chud the Builder, has his own social media history, some of which is being presented as if it's decisive evidence of guilt on his part. Here's an account that writes, another one of Chud's past tweets unearthed. I'm not going to do all of them. This is just representative. Let me attempt to have a constructive discussion without emotions and opinion. We've seen this in his past comments, along with video where he threatens to blow someone's brains out. Legally, how does the DA use this? Legally, how does Chud get around it? Well, I mean, if it's incriminating, you could argue it's a statement against interest. You can get it admitted. But if you contextualize it, and this is what this post says, keep encouraging your fellow blacks to assault me. When you see a chimp with their brains blown out on the timeline, just know you all did this to your own people. People are saying, well, this is obviously incriminating. He's looking to shoot people. I would argue it's the opposite of that. There's nothing wrong, unlawful, inappropriate about letting people know you will defend yourself against an assault. An assault is a criminal attack upon you. You're allowed to defend yourself. You're allowed to defend yourself with deadly force if the assault is of a nature to justify the use of deadly force. So taking these comments even out of context of what he was responding to, this is a lawful statement. If you assault me, I will defend myself. And then I came across this. So this is another law tuber. Legal Bites, goes by Legal Bites. And I've had interactions with Legal Bites before. We've been on some common streams, I think, Johnny Depp maybe. Some of these high-profile cases where lots of law tubers got together in the same stream. I'm not going to say her real name. It's public, but that's not of interest here. She has her own YouTube channel. You can check. In fact, we're going to look at it in just a second. And I raise this because I'm not the only lawyer on the internet commenting about this case. So there are others, and some of the others have differing opinions than I do about this case, and Legal Bites clearly does. And I think it's worth comparing and contrasting the legal analysis of different attorneys. You can decide which you think is most sound, most robust, most consistent with the evidence actually being presented. But you know what? I'm going to circle back to this because before we get to that, let's cover some of the media reports from the hearing. Now, remember yesterday, we covered the affidavit of complaint from the police. Let me pull that up real quick. We covered this document yesterday in detail. It's so short, I'll just read it again. But the point was yesterday that there's nothing in here that's inconsistent with lawful self-defense. It's really remarkable. And it's remarkable what's left out and how much is passive voice. So it's only 2 paragraphs, so I'll just read it again. On May 13th, 2026, Dalton Eatherly and Joshua Fox engaged in a verbal altercation. Okay, I mean, that's not a crime. And I guess at most it's disorderly conduct, a misdemeanor. But that, of course, would apply to both gentlemen. They had a verbal altercation. During this verbal altercation, Dalton Eatherly turned his body in a bladed stance towards Mr. Fox. Okay, why is that a problem? I mean, they're trying to suggest that Eatherly took a combative, aggressive, offensive stance towards Fox. You know what they're leaving out here that we're going to see in the media reports from yesterday's meeting? Dalton Eatherly took this bladed stance only after he had walked away from Joshua Fox, and Joshua Fox pursued him, said, "I have PTSD." In other words, I'm following you and I'm angry. We just had a verbal altercation. And now I'm following you. I'm telling you I have a mental disorder consistent with violence. And what did Dalton Eatherly do? He took a bladed stance. A bladed stance is when you're squared up with somebody and you take a half step back with one foot. That's what that means. You're right if you're right-handed. Presumably, your right foot comes back, your right hip comes back, your right shoulder comes back. It's a defensive fighting stance. We've all seen it. Most of you, if you're men, you've done it. This is a defensive position to protect yourself from a feared, unlawful attack. But they leave out of the affidavit of complaint that this blading stance towards, what's that mean? Towards Mr. Fox occurred only after Dalton Eatherly had withdrawn, was walking away from Joshua Fox after a verbal altercation, and Joshua Fox pursued Dalton Eatherly, told him, "I have PTSD." There's nothing inappropriate about Dalton Eatherly adopting a defensive stance in apprehension of being attacked, which of course actually happened. Took a bladed stance, and Dalton then reached for his firearm located in his right jacket pocket. Now, of course, we don't even know if this is true. This is just a claim by the police. But reaching for a weapon when you already have an articulable apprehension of being attacked is not unlawful. They're not even saying he presented the weapon or pointed the weapon. He reached for the weapon. There's no indication that Joshua Fox would even know at this point that there was a weapon on Dalton Eatherly's person, that Joshua Fox would have had a reasonable fear of a deadly force weapon. He reached for it. That's as far as the state is willing to go in terms of describing Dalton Eatherly's offensive conduct. And then the power of passive voice, I should say the impotence of passive voice. Thereafter, a physical altercation ensued. Like it just somehow manifested. There's no indication of who did what to who. Who struck first? Who raised a fist? Who drew a gun? Well, we don't know. That physical altercation, the two men were just standing there, and suddenly that physical altercation just ensued. We may never know how. Then Dalton Eatherly discharged his firearm. What are they leaving out? What was being done to Dalton Eatherly? Because as we learned in the hearing yesterday, before Eatherly discharged his weapon, Joshua Fox had wrapped his arm around Dalton Eatherly's neck, put him in a headlock. Somehow they leave that out. They leave that out of this affidavit of complaint. He discharged his weapon. There's zero context for why that weapon might have been discharged in a lawful way. Striking Mr. Fox multiple times. By the way, we've heard that Dalton Eatherly managed to graze his own arm with a round. You might have wondered, well, how does that happen? How do you end up shooting yourself? You know how it happens? It happens when someone has your neck wrapped inside their arm and you're bent over and you're pulling a gun and you're trying to get the gun around your own body to shoot them because they're trying to cause you death or serious bodily injury. And that's how you manage to graze your own left arm. Just pantomime the motions yourself. You can see how readily that can happen. That's how vulnerable a position Dalton Eatherly was in when he was compelled to fire those shots. Joshua Fox's arm around his neck from behind. No mention of that here. As a result of being shot, Fox was life-flighted to the hospital. There were several bystanders nearby. Surveillance video shows ricocheting projectiles. Again, sending rounds around the community would normally be reckless endangerment with a deadly weapon, which is one of the charges here against Dalton Eatherly, unless the shots were fired in lawful self-defense, just like shooting someone is normally a crime, unless the shots are fired in lawful self-defense. If this is lawful self-defense, as it increasingly appears to be, there is no crime here. There is no crime. Let's look at the news reports from yesterday. But before we do, I do feel obliged to remind everybody that if you like this kind of use of force analysis, I would urge you to pick this up. Pick this up. This is our best-selling book, The Law of Self-Defense Principles. We give this book away. We give it away. It describes how you can make yourself hard to convict if you're ever attacked like Dalton Eatherly was attacked here by Joshua Fox. Make yourself genuinely hard to convict. It's all written in plain English. There's no legalese. Most people read this book in an afternoon. And if you don't know where the legal boundaries of self-defense are, you are easy to convict. You may think you know where those legal boundaries are, but I can assure you, most of what you know about self-defense law is mistaken. And if you violate those legal boundaries, you become easy to convict. Easy to convict. Keep in mind, when you claim self-defense, you're not saying, it wasn't me, I didn't do it, I have an alibi, I was someplace else. You're saying the opposite of that. You're saying, it was me, I shot that guy, but I did it in lawful self-defense. If your self-defense collapses because you did not know what you were doing, what's left of that statement? I shot that guy in lawful self-defense. Take away the self-defense part, and it's just a confession. I shot that guy. And that's a pretty easy conviction. Don't be easy to convict. Be hard to convict. We give the book away. We only ask that you cover the cost of shipping the book to you. But the book itself is free at lawofselfdefense.com/free book. lawofselfdefense.com/free book. I urge you to take advantage of that opportunity. If you're not willing to pick up a free book to make yourself hard to convict, I don't know what anybody can do. I don't know what anybody can do to help you. All right, so here's a media reports. Actually, I'm going to catch up on, I'll get it ready, and then let's take a look at Super Chats and such. Super Chats, Blaster Brain, $10 says, Legal Bites dropped a video this morning. She's confident that Chud is definitely screwed. Yeah, we're going to look at her video in just a second. We're going to look at a short portion of it. Definitely screwed, mostly citing prior acts in speech and the bladed stance as being aggressive. I'm going to link to, in fact, I'll drop the link for her video in the description after the show, but we're going to look at a few seconds of it. I might cover the whole thing. It's a 20-minute long video. I don't know, should I cover? Maybe I should do a poll on that. I'll do the poll when we get there for all of you. But I might do a breakdown of her whole 20-minute video. I don't want to do it on this show because you never know when these people, if I haven't watched the entirety of her video, so I don't have an opinion right now, but my opinion could be negative. And sometimes when you have a negative breakdown of somebody's YouTube video, they try to get a copyright strike on you. So I don't want to contaminate this show with that. Maybe I'll do a separate show covering her whole 20-minute video. I watched the first few minutes of it, and the first few minutes were not impressive, for sure. So I expect my review to be negative. Glenn Miller, $2 says, "Happy Friday, everyone! Woohoo! 3 days. Oh, is it a 3-day weekend? It's Memorial Day weekend, right? I didn't even realize." Spuds 6423, $2 says, "It's Hawaiian shirt Friday. No tie needed. When I'm working, I've got the tie on. That's how you know I'm working." Moncor, $20. So generous, my friend. The judge imposed a sweeping gag order and social media ban on Eatherly. Does using bail conditions to essentially shut down a defendant's business cross the line into bail being used as an instrument of oppression? I mean, gag orders, I wouldn't say they're common, but they're not uncommon. The judge almost certainly has the discretion to do that. I think it's very unfortunate. Citizen E22, $10. Always a pleasure to see your well-informed opinion. Well, that's very kind of you, my friend. Dorian Shepherd, $5. "Oh, Lord, another L take from Legal Bites. Heaven save us from these law thoughts." Thoughts? That's not very nice. I don't think she's a thought. I think she's happily married, is my understanding. Justin Wright, $10. Dankula's newest video was way more interesting than Legal Bites. Is that right? Let me make a note. Is he on YouTube? I don't watch a lot of other social media, folks, so I don't know many of these people. That's not to be critical of them. I just Count Dankula. Is that who it is? Well, he's got a lot of videos. I don't know. If you want me to look at it, send me a link, and I'm happy to take a look at it. I don't watch Legal Bites stuff either. It's just YouTube. The YouTube pops stuff up in your feed. Obviously, we've all had that experience. Let me take a look for Rumble Rants here. No Rumble Rants. Let's see. There's a couple. Sometimes Rumble just doesn't do it quite right. I won't be able to pop them up on the screen, however, but let me, I'll read them. I will read them and give credit. Gito463, always generous, says, "It may not be appropriate to state you'll defend yourself, but that wording is definitely more provocative than necessary. Brains blown out." He's referring to the tweet, this tweet. Well, I can't pull it up right now. The tweet I showed you from Chud the Builder. I would not encourage making statements like that at all. And I just don't think it's useful. I don't think you're going to deter anybody by doing that. And it can be, depending on how out of context it's cited, it can be used to appear incriminating. Especially if it's more, flamboyant like this one. Hazed Zealot, $10. "Happy Friday, Branca. Hope you have a great upcoming Memorial Day holiday." Well, I'd forgotten it was Memorial Day weekend. Gito463 again. "On your shop, if you click the homepage, it only shows your Branca for SCOTUS mug and no way to get back to the full list of mugs. Your tech guy needs to..." I'll take a look at that. Thanks, man. We have mugs. You see mugs behind, let's see, this way. All these mugs. We have the Branca Show mug. Bam. We have the "What Kind of American Are You" mug. We have the original, of course, Branca for SCOTUS, talking about those unelected black-robed tyrannical inferior federal district trial court judges. We have, and they come in ceramic and travel mugs. You can see a travel mug up there as well. The link for the mugs should be in the description to the show. Yes. In fact, I'll put it in the chat as well. Just so everybody has it. In fact, I'll put it in the chat. That's in there. In fact, I'll pin it. Whoops. Can I pin it? Did it work? Oh, it was too long. I did it wrong. I grabbed too much text. Okay, so the link, I'm going to pin it. Replace pinned message. There you go. And I'll do the same thing in Rumble as well. If you'd like a mug. All right, where was I? Let's see. Here we go. Still reading Rumble rants. Zakuza, $5. How you doing, man? Says Supreme Court Justice Count Dankula is a wild ride sometimes. I'm going to check him out. I wasn't really familiar with his content. And actually, yeah, okay. So that's all the Rumble rants. Let me take a look. We still good. Oh, a few more super chats came in. Not retarded Jason, $10 says, if Fox pleads the fifth and doesn't testify, will the jury be told why he didn't testify? Probably not. Probably not. And I'm not sure why that would be the legal rationale. Now, if Fox were the defendant and he doesn't want to testify, the jury wouldn't be told. The jury would just be told that the defendant does not have to testify. You can't use that against them. That would be part of the standard jury instructions. But he's not the defendant. You know, we're going to hear, as bad stuff comes out about Joshua Fox, we're going to hear on social media over and over again from the anti-Dalton crowd, well, you know, Joshua Fox, he's not on trial here. His bad stuff doesn't matter. He's not on trial. But if he's not on trial, why shouldn't the jury be told? He's refusing to testify on grounds that if he testifies, he could incriminate himself. I don't know. But judges tend to be very sensitive about the whole Fifth Amendment thing. Wina, 123, 20 euros. I have fans in Europe. That's amazing. It says Chud's lawyer issued a pretty weak statement a few days ago. Could be an issue for Chud that his lawyer isn't necessarily on his side ideologically. My bad for the noob question. Sending love from Italy. I love Italy. I wish it would stay Italy. That would be nice instead of becoming another third world nation like so much of Europe, but that's a subject for a different show. Again, just full disclosure, I had a very short 4-minute conversation with Dalton's lawyer, Jake Fendley, yesterday. Nothing substantive. I mean, he presents as a perfectly normal attorney in a 3 or 4 minute conversation. I have seen kind of an abbreviated history of his legal career, and frankly, it's quite impressive. So it looks to me like he's got all the capabilities a defendant would want in a case like this. I did see the statement he released. I don't have any particular comment on that statement at this time. And that was Winus. Super chat. And Doug Allen, $20. Happy Memorial Day to you and yours. Special thanks and shout out to our military members. Indeed. Thank you for your service. Not me, of course. I've never served. But thank you to all of those who did serve and make it possible for a lawyer like me to yell into a microphone for a few hours every day in complete safety and national security. All right, let's see. That looks like all the stuff. The Rumble rants through. Oh, look at this. Look back, 45. What's DKK? Is that Danish kroners? Is that what that is? Here's a little foreign currency. Oh, Denmark. Yeah. Danish kroners. Whoops, that was the wrong button. Thank you, man. I appreciate that. I love Denmark. I've been to Denmark. It's beautiful, beautiful country. Beautiful country. I'd love to go back, and I've never ridden a motorcycle up there. I've done most of Western Europe, but the more southern portions, France, Belgium, Germany. I've never gotten up into Scandinavia on a motorcycle, which looks like it would be a lot of fun. Looks like it would be a lot of fun. All right, let's see what else I have here. Oh, the news reports. The news reports. Let's take a look at this. Because I was really fascinated by this, by what was said and not said in these news reports. Let's see. What is this? $5. 10 baby mamas. Great to see you come around, Andrew. I was on the timeline telling you no slurs used on day one. You never replied and maintained the frame he had. Well, is that an insane frame? We didn't know, of course. I never said that I didn't know whether or not Dalton Eatherly had used the N-word. But that was the biggest vulnerability. That was the biggest threat to any claim of self-defense he would make, because if you provoke the confrontation, if you provoke the need for you to use defensive force, under Tennessee law, you lose the legal justification of self-defense. Why would we suspect that Dalton Eatherly might have engaged in conduct that could be presented as provocation that would lose him self-defense? Well, because he's got a long social media history of engaging in that kind of conduct. I have a little video here that I want to share with all of you, and I've necessarily bleeped stuff out. Why can't I find it? Here, let me start with this. Here we go. So I've bleeped out the N-word and a couple other things here, but I've put text up on the screen of when the N-word is said. By the way, the first person who says the N-word here is the black guy in the blue jacket. But this is representative. This video is very bad for Dalton from a self-defense perspective if the same things had happened with Joshua Fox. Now, this is a different event, so it's not relevant to what happened with Joshua Fox. And increasingly, we have good reason to believe nothing like this happened with Joshua Fox. But this is the kind of video content that Dalton had put out that I was concerned about because of the same things, and this is not the only video, this is just representative. If the same kind of things had happened with Joshua Fox, Dalton's claim of self-defense would be in serious jeopardy. Very vulnerable to defeat by the prosecution. So let's just play this little clip. This is the stuff I was worried about. I didn't know if it had happened with Joshua Fox, but because I'd seen videos like this one, I was worried that it could have happened. And if it had happened, it would have been extremely destructive to Dalton's claim of self-defense. Here we go.
Are you on some shrooms or something? What are you on? I already told you, I'm on your mama's sweet. Okay. You're a bitch, bro. Literally, all you do is talk about your dick.
I'm sorry. I'm
Come back over here.
Okay. Let's
Come back over here.
Let's not fight. I am.
Touch me again. Touch me again.
I don't want to get pepper sprayed. I really don't.
Go pick up my hat. You heard me. Touch me again. Touch me again. That's what I thought. Thank you.
Hey, don't hit me with that shit.
I ain't gonna pray you. Wants to put his hands on me again. Go home with you. Let's go get his ass. Hail Hitler.
Okay, so for all the people saying the N-word is just free speech, and he has a legal right to say the N-word to anybody he wants, including black people. That's true. I can assure you, though, that normies have been conditioned their entire lives to recoil viscerally when they see a white guy use the N-word in the face of a black guy. That's just reality. The jury's probably going to consist of normies who are going to have that kind of reaction. And statistically, given the demographics of Montgomery County, 2 to 3 of those jurors on a 12-person jury for Dalton Eatherly are likely to be African American, and they're going to have a response to watching a white guy hurl a racial slur, the N-word, in a black guy's face. Now, again, this is not the Joshua Fox confrontation, and we have good reason to believe nothing like this happened in the Joshua Fox confrontation. But if this had happened, and the jury would be seeing that and coming to conclusions, and it would look a lot to most people like the kind of provocation that loses you self-defense. Let's watch this again. And by the way, the black gentleman's not entitled to strike the hat off of Dalton's head. That's an illegal battery. That's a crime for which he can be charged.
Or something? What do you want?
I told you I'm on your mama's sweet.
Okay. You're a bitch, bro. Literally, all you do is talk about your dick.
All right, so that's an unlawful battery just committed by Blue Jacket on Dalton. But here's the thing. That doesn't privilege. Now Blue Jacket is running away. That doesn't privilege you to pursue the guy who knocked your hat off.
Sorry, I'm a
Come back over here.
Okay. Let's not
Come back over here.
Let's not fight. I am.
Touch me.
Let's not fight. Let's not fight. So I've talked to you before, if someone provokes a confrontation, and you could say here that Blue Jacket is provoking a confrontation himself, right? By knocking the hat off. But if you provoke a confrontation and then you withdraw from the confrontation and you communicate your withdrawal to the other party, that fight has ended for self-defense law purposes. Now for the fight to continue, what has to happen? The other party has to pursue you, and then they're in effect starting a second fight. Now, I've talked about in the context of how this legal doctrine of provocation, regaining innocence, regaining self-defense could work in Dalton's favor in the Joshua Fox encounter, but it can also work in the other guy's favor. And when we watch this, what do we see? We see Blue Jacket commit a criminal battery, then he walks away, and he says, I don't want to fight. That's Blue Jacket regaining innocence. He's still on the hook for the battery. He could still be criminally charged with the battery. Regaining innocence doesn't work retroactively. But moving forward, now for the fight to continue, Dalton has to pursue Blue Jacket and in effect initiate another confrontation in which he's the aggressor. And that's exactly what Dalton is doing here.
All you do is talk about your dick.
I'm sorry. I'm a
Come back over here.
Okay. Let's not
Come back over here.
Let's not fight. I am.
Touch me again. Touch me again.
And this whole thing, touch me again. Remember the shooting around the people who were putting the mattress in the dumpster, and you had the father and son there in their wife beaters with their guns, and they were telling the mattress people, go ahead, take your swing. I doubt it, take your swing. And then deadly force resulted. The father and son both fired and killed the guy, disposing of the mattress. The father was the one saying those words, take your swing, take your swing. The son wasn't saying anything like that. The father was convicted. The son was not, even though the son fired too. Why was the father convicted? Because when you engage in that conduct, go ahead, take your swing. It's called provocation with intent, a particularly aggravated form of provocation. Because what you're trying to do is you're provoking the other person to being the initial aggressor so you have an excuse to use deadly force against them. Provocation with intent loses you self-defense every day of the week, twice on Sunday. So this whole, and listen, I don't think Dalton's doing this with malice. He doesn't know anything I'm explaining to you. He's never gotten the free book at lawofselfdefense.com/free book. But the law doesn't care what you knew or didn't know about the law. They only care about whether your conduct falls within the legal boundaries or not. And if you engage in provocation with intent, if you do this stuff, touch me again, see what happens. You lose self-defense.
I am.
Touch me again. Touch me again.
I don't want to get pepper sprayed. I really don't.
Go pick up my hat. You heard me. Touch me again. Touch me again.
And now he's going to follow Blue Jacket again.
That's what I thought. Thank you.
Hey, don't hit me with that shit.
I ain't gonna pray you. Wants to put his hands on me again. Go home with you. Let's go get his ass.
Then he says, let's go get his ass. Now, I think I know what he means here. What he means is he's talking to his cameraman. Obviously, he's being filmed by a cameraman. He's talking to his cameraman. Let's go have more interaction with him. This is good social media provocative content. Let's go get his ass. Let's get him on camera again. But how do you think a prosecutor would represent those words? Let's go get the black guy. Let's go get the N-word. I mean, this looks horrible. This looks horrible. Now, again, this didn't happen with Joshua Fox. At least we have no evidence of that. And frankly, the absence of evidence suggests it did not happen with Joshua Fox. But when you say, good to see you come around, Andrew, this was the kind of conduct I was concerned, for good reason, for this reason, had happened with Joshua Fox. Justin Wright, $5, says, YouTube censors do not like Dankula. I at you on X. I think I'm blocked too. My first name and W and a bunch of numbers. I don't know. That doesn't really help me. You can't give me just your handle on X? Will YouTube then allow that? I mean, anyway, I do block a lot of people on X, but I'm pretty aggressive with the block button because otherwise there's a lot of time wasters on there. But if I've blocked any of you and you think it was inappropriate, I'm happy to give people a second chance. If you just ask, I'll unblock. It's fine. Let's see. Covered that. Rachel says, $5. Thank you, Rachel. Seems unreasonable if you verbally insult someone and then they attack you, attempt to kill you, and they're justified. You have no self-defense rights. Don't blame me. It's the Tennessee statute. The Tennessee statute says you could do everything in self-defense right, meet all the conditions for self-defense, but if you provoke the confrontation, you lose the right to self-defense. Now, what qualifies as provoking the confrontation? Is verbally insulting someone, eliciting an unlawful violent response? I mean, they're not allowed to respond with violence to what you say. They're committing a crime. Does that lose you self-defense? Well, guess what? You don't get to decide that. You don't determine that. You don't determine your legal outcome. Other people do. Other people decide whether or not what you did qualifies as the kind of provocation that loses you self-defense. The police, the prosecution, the judge, and ultimately, of course, the jury. I don't make the rules, my friends. I just tell you what the rules are. I'd rather be skiing. $10 says, ego is the greatest cause of stupidity, injury, and death. In my experience, nothing good ever comes from ego or misplaced pride. Yeah, I always urge people, if the worst should happen and you have to defend yourself, this is in the context of not the legal defense of self-defense, but physical self-defense, you really need to be making your decisions in self-defense in the most emotionless, rational, Spock-like manner possible. That's one of the things this book prepares you to do. That's why we urge you to pick up your free copy of this book. It talks about all this. lawofselfdefense.com/free book. Once your ego gets engaged, you're not making better decisions. And the law of self-defense is not well designed for people making emotionally driven decisions. It's just not. You're almost certain to fall outside the legal boundaries. And it's hard to stay emotionless, especially in a deadly force fight where you're facing an imminent threat or death or serious bodily harm, or that threat is to someone you care about. It's not easy to stay coldly rational. But that's what you ought to do. That ought to be your aspiration if you want to make sure you're keeping your use of force within the legal boundaries. Zakuza says, Chud's content is like crack to a prosecutor for this case. Yeah, it is. I mean, it shouldn't be relevant to this case unless that conduct occurred in this case. And Zakuza, $5. Clip it. Branca said he's never ridden a motorcycle. All of those pictures. I've never ridden a motorcycle in Scandinavia. I've ridden motorcycles quite a bit over much of the world, but not Scandinavia. Clip it. Branca said he never has ridden a motorcycle. All those pictures are AI. I'll have to explain the motorcycle expenses then to my wife. That might be a little more difficult. All right, finally, let's get to this news report. Here we go. All right, so this is from local news WKRN was at the hearing yesterday. Let me grab my red pen. During a bond hearing held yesterday, officials revealed new details about what led up to a shooting outside the Montgomery County Courthouse involving Chud the Builder. Now, I want you to focus particularly on what is said and whether it's consistent with self-defense or not. And I also want you to pay attention to what is not said by the prosecutor. Dalton Eatherly, known online as Chud the Builder, was charged with attempted murder, aggravated assault, employing a firearm during a dangerous felony, reckless endangerment with a deadly weapon, for his involvement in the shooting that took place outside the courthouse on May 13th. During Eatherly's live stream, he claimed the incident began, and we're going to listen to that clip because Legal Bites has it in her stream, and we're going to play that portion of her stream. So this is of course, journalists really suck at their job, but she doesn't explain the context of this. After the attack, immediately after the attack, when he's on a gurney, Dalton does a little live stream on Kick or whatever platform he's on, and he's talking about what happened. He claimed the incident began when a man outside the courthouse pointed and laughed at him. Eatherly claims he walks away after interacting with the man. All right, so this is, you might say, well, that's just his claim. We don't know if that's true or not. Fair enough. But it is evidence. What the defendant says about the event is evidence. Whether you believe it or not, or whether it's contested evidence or not, that's a different question. It is evidence. So we have evidence that Eatherly walked away after interacting with the man, who's Joshua Fox. Where's the counter evidence? Where does the state say, no, that never happened? We have surveillance video. We know that never happened. That's a lie. And that's what I mean by the dog that doesn't bark in the night. What's not being said here? If the state is not contesting this claim that Eatherly walked away, the only evidence we have, uncontested evidence, incontroverted evidence, is that Eatherly had an encounter with Joshua Fox and then walked away. Is that consistent with self-defense? Does that make Dalton the aggressor? Eatherly claims he walked, and by the way, this is a contemporaneous statement by Eatherly within minutes after the fight. Eatherly claims he walked away after interacting with the man, Joshua Fox, but Fox followed him and started punching him. Again, this is Dalton saying this. Maybe you don't believe it, but where is the contrary evidence? Where is the state saying that's not what happened? The dog that did not bark in the night. The man followed him and started punching him, which is when, after he began to be attacked, when Eatherly said he drew his weapon. Dalton Eatherly claim. Where is the counter argument? Where is the counter evidence? Where is the state saying that's not true? He drew the gun before there was any attack. Not that that necessarily would be unlawful, but not drawing the gun until Joshua Fox had actually physically attacked him certainly does not weaken Dalton Eatherly's claim of self-defense. Then apparently in the hearing yesterday, surveillance video was shown. So the authorities, the prosecutors, have video of this event. Have you seen it? No. Have I seen it? No. Why not? Because the prosecutors refuse to release the video to the public. If the video is consistent with the guilt, the attempted murder by Dalton Eatherly of Joshua Fox, why wouldn't the prosecution release that video? Or is it more likely the prosecution's not releasing the video because the video's not incriminating? The video's exculpatory. If you were the prosecutor in possession of that video and you knew it was exculpatory, and nevertheless you wanted, for whatever reasons, to prosecute Dalton Eatherly, wouldn't that be a rational reason for you not to release the video because it would undermine your narrative of guilt? So we don't have the video. We can't see it. And the reason we can't see it is that the prosecution won't let us see it. But it was shown in court yesterday. And this reporter was there watching it. And this reporter has a description about what the reporter observed in the video. Surveillance video shown during Thursday's bond hearing reportedly revealed Eatherly approached a man with a selfie stick. This is what Eatherly does, right? And appeared to walk away. What? This is, again, so ambiguous. How do you appear to walk away? If it's on video, can't you observe whether he walked away or not? In what manner could Dalton have appeared to walk away and later you discover, oh, no. It only appeared like he was walking away. He wasn't actually walking away. In any case, this is now another source. Remember, Eatherly claimed he was walking away. Now we have a reporter watching surveillance video of the event, and the reporter says, well, it appeared he walked away before there was any physical confrontation. Dalton Eatherly walked away from that verbal confrontation. However, Joshua Fox was then seen grabbing Eatherly and placing him in a headlock before shots were fired. So Joshua Fox did not attack Dalton because Dalton was bringing a gun into play, because he was being shot by Dalton Eatherly. This reporter who observed this surveillance video says that no shots were fired until Dalton Eatherly had been placed in a headlock. Is a headlock a deadly force attack? If a violent aggressor who tells you ahead of time they're mentally unstable, they have PTSD, was just engaged in a heated verbal confrontation with you, puts his arm, locks it around your neck in a headlock, so you're bent over, they're behind you, you're in an extremely vulnerable position. Is that a position from which that aggressor can readily inflict death or serious bodily injury? Of course it is. That's a deadly force attack. Is that consistent with Dalton Eatherly having engaged in lawful, deadly defensive force? Absolutely. And by the way, again, the dog that did not bark in the night. Where is the prosecution saying that never happened? That's not in the video. There was no headlock. There was no Joshua Fox's arm around the neck of Dalton Eatherly. Where's the state saying that? They're not saying it. And what's the only reasonable inference can we make when the reporter watches a surveillance video? Anyone think this reporter is favorable? Who wrote this? Alicia Patton. Let's see if I can find an image of Alicia Patton. WKRN. Digital content producer. LinkedIn. I'm trying to find a picture. Anybody want to guess? Anybody want to guess what Alicia Patton looks like? This is her LinkedIn page. That's Alicia Patton. That's the journalist who wrote what we're reading. Does anybody think this young black woman would look at that surveillance video in that hearing yesterday and write a false accounting of what that video shows that's favorable to Dalton Eatherly? That seem credible to anybody? We're reading the description written by this young black woman about what's in that surveillance video. So when it's favorable to Dalton, I think that has added weight coming from this particular source. Back to the news report. Alicia Patton. Joshua Fox, seen in the surveillance video, Alicia Patton tells us, grabbing Eatherly, wrapping his arm around his neck, putting him in a headlock before any defensive shots were fired. Authorities arrived on the scene. So authorities had to come to the scene. Found Joshua Fox. I don't know why she never names Joshua Fox. It's always the other man. Everyone knows who he is. found Joshua Fox near the water. He was flown to Vanderbilt University. The defense argues, listen for the dog that doesn't bark in the night. The defense, that would be attorney Jake Fendley, argued Eatherly did not pull out his weapon until he was physically struck. Didn't even pull it out until Joshua Fox was actually physically attacked, not threatening to attack, actually physically attacking him. And you may say, well, that's Dalton Eatherly and his lawyer saying that. We don't know that that's true. Okay. This is in the courtroom yesterday in front of the judge, Judge Hugh III. The state prosecutor standing right there. Where's the state prosecutor saying that never happened? That's not true. We have evidence that Dalton Eatherly drew his weapon before he was ever attacked. Not that that would necessarily be unlawful, but the prosecutor can't even say that. The defense attorney is standing right there next to him saying, hey, my guy Eatherly didn't even pull out his gun until he was already being physically struck. And the prosecution's like, nothing to say about that. What did they say? Oh, well, prosecutors questioned investigators about Eatherly's intentions, adding that before the incident, he made posts online about going free and riots in the streets, though the full context was not revealed in court. How is this inconsistent with lawful defense against a physical attack upon you that happens later in the day? When you were walking away and had to be pursued by your aggressor for the fight to happen. So that's how prosecutors responded to this claim by the defense. My client didn't even pull out his gun until he was being beaten. They say, yeah, but he made some ambiguous statements earlier in the day. Not saying this isn't true, not contesting this presentation of what happened by the defense. Eatherly is known to film himself saying racially derogatory statements to black people in public settings. Yes, of course, we know that. Prosecutors brought up Eatherly's behavior online and mentioned that he's known to confront people in public for content, attention, and money. Arguably true. The defense argued that posts that were made weeks or months before the shooting should not count as provocation in relation to the shooting outside the courthouse. This is absolutely sound legal argument. The kind of provocation we're talking about in the context of self-defense law is you're engaged in conduct that you have reason to believe will provoke an immediate violent response. That's not statements you made weeks or months earlier. There's no risk of an immediate violent response when you're doing a social media post. So Jake Fendley is 100% on the mark here. As videos were played in court, another live streamer was reportedly removed from the courtroom. I believe that was Jake Lang. If you don't know who Jake Lang is, I'm not going to go into Jake Lang, but he likes to go to these high-profile events and make sure that he's visible on the cameras for them. He's kind of his own, provocative social media content creator. Got himself arrested, taken into custody. And apparently the judge had made an announcement, I'm not going to allow any disruptions in my courtroom, and he disrupted the courtroom. So that's direct contempt of court. That's good for 10 days in counting. Some of Eatherly's family members testified he has strong community ties, family support, used to work in local construction. One family member allegedly acknowledged a prior arrest involving Eatherly, but clarified the arrest did not result in a conviction. Based on the calculations of the customary bond amounts tied to each charge, the judge set the final bond at $1.25 million. Stressed the seriousness of the charges. Well, they are serious. 60 years in prison is no joke for attempted murder in the first degree. And even if he makes bond, he would require GPS monitoring, which actually is quite expensive, if you didn't know. The defendant has to pay for that. And restrictions on social media activity. That's the gag order. All right, so all I'm seeing in this news report, written by a young black reporter, female, written by this woman, is evidence consistent with lawful self-defense by Dalton Eatherly, evidence consistent with Joshua Fox being the unlawful aggressor in this physical confrontation, and the state prosecutor standing right there and not contesting any of that. The dog that did not bark in the night. And we know now for a fact there is surveillance video that captured this event, which is in the prosecutor's possession, and they will not release. Why? If it's incriminating, why wouldn't they release it? The job of the prosecutor is not supposed to be to secure a conviction. The job of the prosecutor is supposed to be justice, the pursuit of truth. Why would releasing the videos be inconsistent with the pursuit of truth? The only reason I can infer that the prosecution would not want to release these videos is that they're not incriminating. They're exculpatory for Dalton Eatherly. Based on the description of the video from this woman, this young black female journalist. A second news report. This one I'm going to do the same thing. Let's look up the reporter. I already know what this reporter looks like, but I don't have her image saved. So, but I think it should be pretty easy to, it's an unusual name. Here it is. Let's see if I can, I just want to pull up the image. Let's see. Let me pull it up here. I've got it. The next news report we're going to take a look at is was written by this woman, Jasmine Logan, young black woman, I presume. In this day and age, I guess you never know. I'm going to presume a young black woman. Does anyone believe that this young black woman is going to fabricate reporting that's favorable to Dalton Eatherly? So if she writes anything that's favorable to Dalton Eatherly, I'm going to take her at her word. I don't believe she would lie in Dalton's favor. I don't think any of you do either. I don't think any of you do either. So let's look at Jasmine Logan's news reports. Also about yesterday's hearing. And see what's said. And importantly, look for the dog that did not bark in the night. See what is unsaid as well. Here we go. There she is. Jasmine Logan. Jasmine Logan. Detectives investigated the May 13th shooting outside the Montgomery courthouse, detailed some of their findings during a bond hearing on yesterday, including the recovery of a bulletproof vest and an airline ticket to Istanbul. And again, people see what they want to see in these things. She's trying to suggest something nefarious about having a bulletproof vest and an airline ticket. Are people allowed to have airline tickets? Is Dalton allowed to go on vacation? Even to Turkey? Are you allowed to have a bulletproof vest? Well, maybe not everywhere, but in Tennessee you are. I personally own a plate carrier with plates, a bulletproof vest. I think it's prudent in a world of increasing violence and instability. There's nothing unlawful about owning a bulletproof vest, at least in Tennessee. There's some gun control states that do make it illegal. Dalton Levi Eatherly, 28, charged with shooting Joshua Fox when several other people were milling around the plaza, as one would expect, charged with attempted criminal homicide, employing a firearm during the commission of a dangerous felony, aggravated assault, reckless endangerment. Initial bond was set at $1.25 million on Thursday. Yesterday, Judge Hugh Reed Poland III reset bond at a mere $1 million. Now we're going to talk about the surveillance cameras. You think her description, Jasmine's description of what she saw on that surveillance video yesterday in court, you think if she describes it in a way that's exculpatory, that she's lying in favor of Dalton Eatherly? I don't think so. But let's see what she has to say. During yesterday's hearing, the sheriff's office investigators testified that surveillance video camera documented the confrontation. So they have video of the confrontation. Where is it? Why is it not released? Why would the prosecutor not want us to see incriminating video unless, of course, it's non-incriminating. At about 1:15, Eatherly approached Fox. Fox was at, she doesn't mind saying Fox's name, unlike the other reporter. Eatherly approached Joshua Fox, who was at court that day for a child support hearing. Eatherly had a selfie stick in his hand. They like talking about the selfie stick. Anyone ever held a selfie stick? Is it much of a weapon? After the verbal altercation, Eatherly walked away. Jasmine Logan is watching the surveillance video of this event, and how does she describe what happened? There was a verbal altercation, and then Eatherly walked away. Even if Eatherly had been provoking, he regains innocence when he withdraws from the confrontation and communicates his withdrawal. And by the way, generally the communicate the withdrawal is not explicit. You don't have to say, I don't want to fight you, although that's helpful. Usually the communication is constructive. The very act of walking away, you clearly don't want to fight someone when you're walking away from a confrontation. Eatherly, Jasmine Logan, young black female journalist, watches this video and says, oh yeah, there was a verbal altercation, but then Eatherly walked away. So how did the fight happen if Eatherly walked away? The fight happened because Joshua Fox pursued Dalton Eatherly as Eatherly was walking away. After Fox was pursuing him, and of course we've seen the reports where Fox is saying, I have a mental disorder consistent with violent behavior, right? You know, after a verbal altercation, you don't pursue that other guy and then tell him, I have PTSD, unless you're trying to make him aware that you're irrationally prepared to engage in violent conduct. Fox approached Eatherly. At that point, after being approached, Eatherly turned his body in a bladed stance, which we've already talked about. That's a defensive position, and reached for a firearm in his pocket. Did he display the firearm? Did Joshua Fox know that Eatherly had a firearm? Not a word about any of that. The dog that did not bark in the night. Is anyone saying Joshua Fox initiated his attack upon Dalton Eatherly because he was afraid he was about to be shot? Why is no one saying that if that's the case? Why is the prosecution not making that claim? Unless it can't be made, because it's just not true and the evidence doesn't support it. Thereafter, the passive voice of physical altercation ensued. Eatherly told investigators he was not reaching for a gun, but for mace. Investigators did not find any pepper spray on Eatherly's body, in his truck, or his house. So here's the story here. We saw the video clip before where Dalton Eatherly was pepper spraying the black man in the blue jacket, right? Eatherly is commonly seen with pepper spray on his person, like clipped on his belt, held in his hand, sometimes using it on people. Apparently, Eatherly had a recent interaction with police in which they took his pepper spray away. So although he habitually carries pepper spray, so you would normally, by default, you would expect it to be where you habitually carry it. He didn't have it this day facing Joshua Fox because the police had just disarmed him of his pepper spray. So that's why both of these things can be true. He can say, I was reaching for my pepper spray and then it wasn't there. And that's why it wouldn't be found, because it had already previously been seized by police. Investigators said Eatherly fired several shots, 7 shell casings at the scene, all from the same gun, probably. Fox was shot in the torso and arm. He's a veteran. That's the positive spin on the PTSD claim. Was not in court on Thursday. Not in court for this hearing, which is not surprising. Doesn't surprise me. Eatherly also suffered a gunshot wound, apparently shooting himself in the arm because Joshua Fox had his neck wrapped in his arm. That's a difficult position from which to shoot defensively. Investigators searched Eatherly's truck and his home. They found an airline ticket to Istanbul, dated for today, 9 days after the event. They also found a bulletproof vest, a rifle, a shotgun. I wonder if that's unusual, rifles and shotguns in Montgomery County, Tennessee. Oh, and there's ammunition and a suspected bag of marijuana. It's funny they have to call it a suspected bag. that there wouldn't be a ready test. They could say a bag of marijuana, a leafy green substance that tested positive for marijuana. By the way, in Tennessee, marijuana is illegal. There's no recreational, there's no medicinal marijuana. Thank God. Thank God. Oh my God, I can't tell you what legal pot has done to the state of Colorado and Denver in particular. It's been a catastrophe. One of the reasons we chose Tennessee to move to, we're moving there in a few weeks, is because marijuana is not legal. We don't have to smell that disgusting stench everywhere we go. They also recovered Eatherly's electronic devices for evidence. They mentioned several racially inflammatory videos and social media comments he'd posted leading up to the shooting. But what's missing here? What are they unable to say? What are we not hearing? The dog that did not bark in the night. There's zero evidence that the state can present that Dalton Eatherly engaged in any racially inflammatory conduct in his interaction with Joshua Fox. None. Not a racial slur, nothing. Then they get to the bond conditions, which we already talked about. Let's see if there's anything relevant about the events. He had recent arrests in both Montgomery and Davidson County. Davidson County would be Nashville, where he was interacting with Blue Jacket earlier. That was Nashville. If you're not familiar with the city. And other charges in Nashville for disorderly conduct, resisting arrest, and theft. That's probably the Bob Steakhouse event, and an unrelated civil case. I think he has a number of civil cases related to not paying debts. I think it's been impossible for him to work, more or less, because of his racially inflammatory content. He's been, canceled, basically. BLM has pursued him, called everybody who might employ him. Has Dalton's mother has been harassed by BLM. All the stuff that the left does in the normal course of events. All right, so we look at those news reports from the hearing yesterday, and all I'm seeing is Dalton Eatherly's narrative of self-defense getting stronger every day. The evidence that is being shared is consistent, exculpatory, strengthens self-defense, that whatever verbal interaction he had with Joshua Fox, even the young black journalist reporting on this event, Jasmine Logan, and I lost the other one. I had it. Oh no. Well, it's not important. Alicia Clark, right? That was her name? Jasmine Logan and Alicia Clark, both young black women. Their reporting of what they saw in that surveillance video is favorable. What they described they saw is a verbal interaction, Dalton Eatherly walking away from that interaction and being pursued. This is Alicia Patton. These two young black women both describe this event as Dalton Eatherly walking away from Joshua Fox before anything physical happens, Joshua Fox pursuing him, striking him, putting him in a headlock as Eatherly was trying to walk away. That is entirely consistent with lawful self-defense. And I believe them because I don't think these young black women would lie in the interest of Dalton Eatherly. I just don't believe it. All right, let's take a look. The other thing I had lined up was this Legal Bites stuff. In fact, I'm going to set up a poll. On how can I do it? Should I do it? I can do it I'll do it in StreamYard. So, Should I, I'll say breakdown, do a breakdown of the full. We're just going to look at a few seconds of it here. Legal Bites video on Dalton Eatherly. Now, you don't click on the poll. The way StreamYard does it is you have to put an answer in the comments. One for yes and two for no. Okay. And this would be a separate show. I'm not going to do it today because we're already going an hour and a half. And I want a separate show just in case Legal Bites gets mad and tries to hit me with a copyright strike and have it taken down. I don't want this show taken down too. Should I do a video breakdown of the full Legal Bites video on Dalton Eatherly? One for yes, two for no. And I pop it up on the screen. Do you see it there? So you have to put one in the comments in the chat or two in the chat, okay? To let me know how you'd like me to proceed there. And while we're doing that, I'll catch up on a couple super chats here. BD Meme, $5 says, will Dalton receive conviction on having a weapon and using a weapon, even if found not guilty because of bail restrictions, keeping his Second Amendment? I guess I don't understand the question. You can only be convicted of being in unlawful possession of a weapon if your possession of the weapon's unlawful. Now, I have heard it said, let me see if I had that. Someone had mentioned to me that there could be an issue around the gun possession. Let me see if I can find it. I know I saved it, and I meant to set it aside. Oh, darn it. Oh, here it is. I found it. So let me pull this up. So this account, who's been, is a good account to follow on X, writes, I've got some unconfirmed reports that Eatherly was subject to a no gun, no weapons bail condition stemming from his October 2025 harassment case. If this was the case, Eatherly's self-defense claim becomes tougher because he was engaged in criminal activity then, because it's a crime to be in possession of a weapon if you have a bail condition, if you're violating a bail condition that says no weapons. It's a Class A misdemeanor for violating the bail condition. Now, I don't know. I haven't seen, he says, unconfirmed reports. I don't know if the bail condition is true, but let's assume for purposes of discussion that this bail condition did say he was under a bail condition that said no weapons and he was violating the bail condition. If that's true, it is a Class A misdemeanor, and that does affect his self-defense claim, but in a limited way. It doesn't lose him self-defense. But many states that are stand your ground states, so you do not have a legal duty to retreat before you can use force in self-defense. If they're stand your ground by statute, it's common for the stand your ground statute to have conditions that have to be met to qualify for stand your ground. If you don't qualify for stand your ground, you still have self-defense, but you may have reacquired a legal duty to retreat before you can act in self-defense. You don't get to stand your ground anymore. And the Tennessee stand your ground law is conditioned on being in a place you have a right to be and not being engaged in criminal activity that's either a felony or a Class A misdemeanor. So if he was violating a no weapons bond condition, that's a Class A misdemeanor, and that would lose him stand your ground under Tennessee law. So he would reacquire a legal duty to retreat. But here's the thing. that legal duty to retreat, even in the most aggressive legal duty to retreat states like a Massachusetts or a New Jersey, you only have the legal duty to retreat if it's practicable and if you can retreat with complete safety. You're not required to try to retreat if it's impossible to do that, like someone has you in a headlock. And you're not required to retreat if it would increase your jeopardy. Here, Dalton Eatherly didn't go to his gun until he was already under attack by Joshua Fox. He'd already tried retreating. He was walking away when he was attacked. And now he's in a headlock. I would suggest safe retreat is neither practicable nor possible. So even if he required a legal duty to retreat, it wouldn't matter. It wouldn't matter. So I'm not too worried about it. And then he just has the traditional straight up self-defense argument. Blue 199 says, read the detective statement that took the stand. Do you have it? I haven't seen that. I haven't seen it. Account Steve 23, member for 9 months. Well, thank you for that support, man. If Dalton did not say anything racist, can his prior acts or character evidence, social media posts, be kept out of the trial? They wouldn't be relevant. You know, the truth is, whether evidence is admitted or not is at the discretion of the trial judge, and it's almost completely not reviewable. Appellate courts will only review for abuse of discretion. They could disagree with the trial judge. They could say, if we were the trial judge, we would not have admitted that evidence. But that's not enough. They would have to. The Court of Appeals would not reverse a decision or reverse a conviction because of what they think is an admission of evidence they would not have admitted if they were the trial judge, unless it's an abuse of discretion, meaning essentially no rational judge would ever have admitted that evidence. And when the review is for abuse of discretion, it's almost never found to be abuse of discretion. And therefore, they're deferring to the trial judge. So it's one of the reasons you really need a good lawyer in court, that you can't count on, if I get convicted, I'll appeal. Appeals are for losers. I mean, you lost that trial. That's why you're appealing. And now every legal presumption is against you. The Court of Appeals looks at everything in the light most favorable to the conviction, now that you've been convicted. So you really need to get all your legal arguments won at the trial level, right there. There really is no practicable second opportunity to make the legal argument. You need to win the legal argument the first time you make it in front of the trial judge. And by the way, I've been getting a lot of inquiries because, of course, my law practice is as a criminal defense attorney who does legal consulting to other lawyers. My clients are all other attorneys who, like Dalton's attorney, are representing clients in a use of force event. And I provide my legal expertise on use of force law to those attorneys to make sure they're making the most compelling, legally sound, comprehensive legal argument for their clients in that use of force case that's possible. I mean, I don't say this to brag, but I'm unquestionably the most experienced lawyer in America dated exclusively to doing use of force law. And we provide those legal consults, but we only provide them, I'm only part of the legal team, to people who are members of our Law of Self-Defense service, our Law of Self-Defense Platinum membership. Let me pull that up. So the benefit of being a Platinum member of Law of Self-Defense is if you're involved in a use of force event, I'm on your legal team. I'm consulting to your lead attorney, and I'm doing it for free. There is no charge. There is no retainer. When we used to take outside consults, if hypothetically, for example, I were to make an exception and do a consult for Dalton Eatherly, my minimum retainer is $10,000. But if you're a Platinum member, you get that for free. And really, our policy is we only do consults for Platinum members. The good thing is being a Platinum member is not expensive. It's only about $1 a day. And you are guaranteed to have me on your legal team, guaranteed to have me there making you as hard to convict as possible if you're compelled to defend yourself, your family, or your property. So if you're interested, and people have been asking me, how do I sign Dalton up for this? Well, I mean, you can, but it wouldn't help them because it doesn't apply retroactively. You have to have been a platinum member at the time of your use of force event. That's how that works. So if you want any possibility of me being able to be on your legal team, should the worst happen for you, you need to be a platinum member. It's $1 a day. I'm not telling anyone to sign up. If you're not interested, it's fine. I don't care. But if you think it would be helpful to have me on your legal team, should the worst happen, for $1 a day, become a platinum member. That's how that works. And you can learn more about that. Either scan that QR code or go to lawofselfdefense.com/platinum. Lawofselfdefense.com/platinum. And then you have, I would argue the highest prospects of winning those use of force legal arguments at trial when it really matters, when it counts. So about the evidence here, might the judge admit? I would argue certainly that they're irrelevant. They have nothing to do with Joshua Fox's attack on Dalton Eatherly, and therefore Dalton Eatherly's necessary defense against Joshua Fox's attack. There was nothing in those clips that could justify Joshua Fox's attack. There's nothing in those clips that could qualify as the kind of provocation that would arguably lose Dalton Eatherly's self-defense, because a social media post, a video that's posted, cannot provoke an imminent violent response from someone in the future. That's not what imminent means. So I would certainly argue that they're all irrelevant. Does that mean the judge wouldn't let it in? No, the judge might let it in. Many of you are familiar with the Alec Murdaugh murder trial down in South Carolina, was it? Where he was charged with murdering his wife and his son. And Alec Murdaugh is unquestionably a complete degenerate. He was a lawyer. He was stealing money from his law partners. He had a terrible drug habit. He was stealing money from his law partners. He was stealing money from his clients. He was stealing money from severely handicapped clients who desperately needed that money, and he was just stealing it to pay for his drug habit, to pay for his family's lifestyle. And he pled to those financial crimes, and he's going to serve the rest of his life in prison appropriately for those financial crimes. So I'm no fan of Alec Murdaugh. He's a degenerate thief. But I don't believe he killed his wife and son, or more accurately, I don't believe the state proved beyond a reasonable doubt that he killed his wife and son. And one of the problems in his trial was the prosecutors did not have a strong case. And they buttressed their case by introducing before the jury weeks of testimony that had nothing to do with the murder of the wife and son, weeks of testimony about Alec Murdaugh's admitted financial crimes. Well, of course, that colors the jury's perception of Alec Murdaugh for the murders as well. And he was ultimately convicted. Now, he just was awarded a new trial, in part because the Court of Appeals had very severe concerns about the extent of those weeks of financial crimes testimony. They didn't reverse on that basis, but they reversed on other grounds. But in their opinion, remanding for a new trial, they wrote about all that evidence, that weeks of finance, and they told the trial court, listen, you got to be careful about this. You can go too far. You can go so far that you're violating due process of law. Could that happen here? Could this judge let in every video clip in which Dalton's saying the N-word? Yeah, that could happen. And that would be hard to fix if it happens. It's up to the judge. Law of self-defense. Thank you, Shane. We got a lot of, before I get to the Legal Bites clip, I'm going to cover in just a moment. We have, of course, over at Law of Self-Defense, where we have the Platinum service. We have a membership there, and they're watching this video too, and they're chatting away in the chat. Let's see. Law of Self-Defense member Denver says, I do not have all the facts yet, but wonder what was the justification for use of lethal defensive force? It's my understanding that Fox at this point was the aggressor, and therefore self-defense was justified. But why would lethal force be justified? Was Fox using some weapon? Was he much more physically powerful? I would argue that we call it a headlock, but it's an arm around another person's neck, bending them over in a very vulnerable position from which it's almost impossible for them to defend themselves without resorting to a deadly force weapon, a gun or a knife. If you've ever tried to fight back from a headlock, it's very difficult, and you're extremely vulnerable. That other guy can punch you all day. He can wrench your neck. He can take you to the ground. He can plow your skull into the sidewalk. I would argue just the vulnerability to death or serious bodily injury from the headlock alone would qualify as a deadly force attack, an attack reasonably capable of causing death or serious bodily injury, and that's what justifies a deadly force response. Denver says, to what extent would Chud's prior statements be disallowed due to being highly prejudicial versus probative? Yeah, that would be the argument. So when you're offering evidence to be admitted, it can be challenged on the grounds that it's prejudicial. Now, of course, all evidence submitted by the prosecution is going to be prejudicial. That's why they're submitting it. But the question is it more prejudicial than probative? Prejudicial, meaning, of course, it makes the defendant look bad. Probative means, does it help? Is it of a nature that it would help the jury answer a legal question in the trial? Determine whether or not it's more likely than not, or not more likely than not, but whether a fact, help them decide whether a fact in contest, that's part of an element of a criminal charge or a legal defense, is true or not. It's part of whether or not the evidence would be relevant to the legal arguments and legal defenses being made. So what ideally, you want evidence that although it may be prejudicial, it makes the defense look bad, it's also probative. So ideally you want it to be sufficiently where people get into trouble admitting evidence is where it's extremely prejudicial, but not probative. Say, for example, there was evidence that a defendant charged with murder had once stolen a candy bar as a child from a local convenience store. Is that prejudicial? It's a theft. Does it have any probative value? Does it help solve the question of murder decades later? The answer is no. So although it's not super prejudicial, but it's more prejudicial than probative. That would be the legal argument the defense would make about Dalton's clips. They're prejudicial and they're not probative. They're not relevant to this encounter with Joshua Fox. And of course, the state would argue it is probative. It is probative because this is a pattern of behavior, a modus operandi, and those are the arguments that would play out in court. Zach says, prosecutions against lawful self-defense will continue until prosecutors face some kind of consequence. Currently, there's extremely limited legal recourse for people acting lawfully in self-defense. Yeah, the only recourse you have is to win at trial. And that's extremely expensive. I mean, I mentioned that when I used to do outside consults for people who were not platinum members, my minimum retainer was $10,000. That's a lot of money. But it's a tiny fraction of a defense in a killing case. If you're charged with murder or manslaughter, the cases I consult on, it's very common for that defendant to burn through $200,000 or more before they even get to trial, just in the pre-trial proceedings. So it's extremely expensive. It's extremely damaging. I mean, often you're locked up for months awaiting trial, or even if you're out on bail, you're not making any big life decisions. If you're on trial for murder, you don't know if you're going to be convicted and spend the rest of your life in prison, right? You're not having kids. You're not buying a house. You're not going to college. You're not starting a business. Extremely destructive. We should not be getting into fights we don't need to be getting into. But should the worst happen and you have to defend yourself and you're being prosecuted, the recourse is to win. Be hard to convict. By the way, if you are hard to convict, if you look hard to convict to the prosecutor, they don't like to take those cases to trial. Prosecutors have a very high conviction rate. It's like their report card. Conviction rate, 90%, 95%. They want to keep it high. And so they have plenty of easy cases to bring to trial. They have possession cases, drug possession, child image stuff. Those are easy convictions. You just got to show the defendant was in possession of the illicit material and it's a conviction. You want to look like the hardest case on his desk. The harder you look to secure a conviction, the less likely you are to go to trial. Unless, of course, there's some kind of political motivation, as there appears to be here. Even then, what do? you as a defendant, you still need to win. It helps if you know what you're doing in self-defense. It helps if you're giving your lawyer good facts from which to build a robust case of self-defense. And largely your lawyer is stuck with what you give him. That's just the reality. You give him bad facts, it's going to be a very difficult defense. Denver says, just heard you note the headlock, which indeed would have created the threat to Dalton of deadly force. It would seem that much of the state's strategy will be to deluge the jury with Dalton's prior provocative statements, whether none, one, or many of those prior statements will be key to the jury's emotional state to rationally consider critical evidence. Yeah, and it could be very damaging. Again, whatever you think of the First Amendment and the N-word and all that, normies respond, they viscerally jerk back when they see a white man calling a black man the N-word to the face. They just do. And on a 12-person jury in Montgomery County, Tennessee, given the demographics, you're likely to have 2 or 3 people on the jury who are black. How are they going to respond to that? Unemotionally? Zach says, how is the judge coming down so hard if the evidence is so favorable to self-defense? Well, again, you have to keep in mind, I'm looking at the end game with all of this, right? I'm looking for how does the state build a narrative that can disprove self-defense beyond a reasonable doubt and secure a conviction. That's not where the prosecution is at this stage of the proceedings. They don't have to prove guilt beyond a reasonable doubt yet. That's not the threshold they have to reach here. This is all just probable cause stuff, which is a very, very low threshold. So the state has enough, arguably, for probable cause, and that's all they need to have. What I'm doing is I'm looking at, all right, where's all the available evidence we have a chance to look at and what's not being said? And looking at all that, because I don't really care about probable cause. Probable cause is almost always satisfied. I care about proof beyond a reasonable doubt and disprove a self-defense beyond a reasonable doubt. I'm just not seeing it. But at this point, the judge is only being tasked with making probable cause decisions. And of course, bail decisions. And at that very, very low standard, arguably, what the state's not obligated to tell both sides of the story here, and it's not really an adversarial process yet here. Denver says, Zach, these are just preliminary bond hearings. Everything can change once rulings are based on actual evidence. Yes. Zach says, so the judge has to take the charges at face value, essentially, is what you're saying. I mean, I guess that makes some sense if the evidence hasn't been properly. Yeah. So the judge is going to look at that affidavit of complaint and take it at face value, assuming everything in this statement is true. Is there a probable cause? That's the standard. I have to say, I think under a proper measure of probable cause, is it more probable than not that Dalton Eatherly committed these crimes, that it was not self-defense? I think this affidavit of complaint fails. But for practical purposes, probable cause is almost a 0-level threshold. So if there's any way to look at the claims of the prosecutor as true, has probable cause been met, is the standard. That's why I say it's so incredibly low. Zach says, I would also imagine Dalton's prior social media conduct would influence these early decisions. Yeah, I mean, the criminal justice system is not a bunch of robots. It's not AI. It's human beings. And the judge will have seen these clips. Right? That's going to influence his decisions. He's a human being. The prosecutor, the cops. The whole point of the trial itself, of course, is to strip out the emotions and make reasoned-based verdicts. Let's see. Paul, I wonder why their respective employers sent young black reporters to this bond hearing. I used to see the same thing in Philly years ago when Channel 6 WPVI would send Vernon Odom, a black reporter, to cover any news story that had a racial component. Denver, years ago, there was legislation introduced to hold prosecutors accountable. But of course, this did not pass. Branca talked about it at the time. Yeah, it's impossible to hold prosecutors accountable. They have effectively perfect immunity, even from what I would characterize as malicious conduct, hiding evidence, faking evidence. It's contemptible. I know you're all thinking about the Nifong guy with the North Carolina men's sports team, right? They were falsely accused of rape, and the prosecutor basically cooked the evidence and got caught, and he got prosecuted. But it happens so rarely, it's not even worth talking about. Let's see. So that catches up. Let me check the Rumble rants. Oh, there are a couple Rumble rants. So let me take a look at this. Jonathan, $5 says, the process is the punishment. Objectivity in journalism is dead. Race makes law enforcement selective. Anti-whiteism is racism. It underlines this entire case. Yeah, hard to disagree with any of that. Mike in Miami, can a bystander step in to defend a person who provokes a fight if they're getting injured badly? Or do they inherit no right to deadly force also? I always carry pepper spray to climb a matrix. Thank you, I think. So the legal standard, if you see someone else in a fight and you intervene, you come to defense of others, you think you're defending an innocent person. The legal standard used to be something called the alter ego standard, where you're basically stepping into that person's shoes. So if it turns out later they would have had no right to self-defense, the legal defense of self-defense, because, for example, they provoked the confrontation, then when you step into their shoes and defend them, you also have no right to argue the legal defense of others for your use of force. That's not really the legal standard anymore. So the legal standard today is you're not literally standing in their shoes. You could be mistaken in believing that they would have a right to self-defense. As long as your mistake is a reasonable mistake, you would be good to go. That's how that works in defense of others. All right, well, the survey definitely says that you want me to cover the Legal Bites thing as a full show. So I will go ahead and do that, but it'll be a separate show. Maybe I'll do that. Maybe I'll do that tomorrow, Saturday. I'll have to talk with my wife. So I'm going to stop the poll. 97%, about 70 people voted. 97% of you want me to cover the Legal Bites thing. So with that said, let's get to the little clip of the Legal Bites thing. Now, obviously, many of you have been watching all my coverage. You certainly watched my coverage of this. So you know I have thoughts about the viability of the self-defense claim of Dalton, Eatherly here. I think he's got a robust claim of self-defense, and I'm not seeing what I would need to see from the prosecution to believe they can disprove self-defense beyond any reasonable doubt, which is their burden. But not every lawyer agrees, right? So here we have Legal Bites. Legal Bites. She says, law of F around, find out alert. Racist streamer, Chud the Builder, real name Dalton Levi Eatherly, was charged with attempted murder last week after he shot a man outside a Tennessee courthouse. After he left a hearing on a civil case, he claims it was self-defense, but there are glaring issues with that argument. Are there? And on top of that, he made some big voluntary admissions to the police that are likely to go a long way in proving attempted murder instead of self-defense. And I thought to myself, what are these big voluntary admissions that are inconsistent with self-defense? What would those be? So I asked her, I wonder if she replied. I asked her, I said, what were these big voluntary admissions that are likely to go a long way in proving attempted murder? I await with bated breath. See some of the contents. Wouldn't these admissions be mentioned in the affidavit of complaint? Of course they weren't. We saw that. You're obsessed. Okay, I'm just covering the case. Covering the case. Somebody writes, shitty lawyer alert. I'm not sure if they're talking about me or Legal Bites. Doesn't matter. Told police on stream he was attacked and acted in self-defense. Well, that's my recollection of what he said. That's not inconsistent with self-defense. So here's her stream here. And I should open up her YouTube channel. Maybe you would enjoy her content. Let's see. Did it open up at the right place for me here? So here's her channel, Legal Bites, BYTES, Legal Bites on YouTube. and I skipped the beginning. I'll do a separate show with the whole 20 minutes here. But I wanted to jump to the part she's talking about. This part. This part. He made some big voluntary admissions to the police that are likely to go a long way into proving attempted murder instead of self-defense. So I jumped forward to what she's referring to here. Let's see what she has to say.
Before that, we're going to talk about what happened after the hearing. According to local reporting, at around 1:15 p.m., Chud walked out of that hearing into Millennium Plaza right outside the courthouse. He claimed he encountered a group of guys pointing and laughing at him. And instead of just walking away, he decided to confront them. Here it is in his own words in a statement to first responders after the shooting, which he live streamed to his audience on Pump.
Okay, so these are the words that Legal Bites is saying are the big voluntary admissions to the police that are likely to go a long way in proving attempted murder instead of self-defense. So they're inconsistent. They're contrary to lawful self-defense. Let's listen to what Dalton Eatherly actually said that Legal Bites believe is incriminating and contrary to lawful self-defense.
I walked past him, he was sitting on the corner. I walked up to him because they were pointing at me. They were laughing, they were pointing at me, and I said, "What's up, guys? How y'all doing?" I said, "Y'all like the new suit?" He said, "Walk away from me." I walked away from him. He came back up to me. He literally said, "I have PTSD. I feel like I'm in." He said, "You start saying all that chimp out shit to me, I'm gonna hit you." He hit me, started wailing on me.
He hit me, started wailing on me.
Started wailing on me even after I had to defend myself by shooting him. He was still wailing on me.
But here's an important detail.
How's that? How are those words? How are those words going to go a long way in proving attempted murder instead of self-defense? What I just heard was self-defense. I saw people pointing and laughing. I walked up, said, "Hey, how you doing? Do you like my new suit?" They told me to walk away. I walked away and they attacked me. And they kept attacking me. Joshua Fox kept attacking me. How is that inconsistent with lawful self-defense? I don't get it. But I will. Where is it? I will cover the her video in its entirety.
This rage-baiting race.
Whoop. Look how she keeps her analysis, emotionless and impersonal.
This rage-baiting racist streamer.
You can't even look me in the eyes.
I think I know exactly what you're doing.
Yeah.
Just.
Okay, I'll cover the whole thing for the legal analysis components as a separate show. Let's see. Tom Forsyth, Canadian, $10, says, "I'm Canadian." Okay. The only thing I'm allowed to use for self-defense is sarcasm. It's just great. Yeah, I'm sorry to hear that. You guys have it tough up there. Leanne became a new member. Welcome, Leanne. And Roger Wood. Oh, was there an echo? There was an echo on the Legal Bites? Oh, darn it. Oh, my gosh. All right. I'm going to play it again. I've got to get a producer. I'll play it again. Hopefully it'll be good now. Here we go.
After the hearing. According to local reporting, at around 1:15 p.m., Chud walked out of that hearing into Millennium Plaza right outside the courthouse. He claimed he encountered a group of guys pointing and laughing at him. And instead of just walking away, he decided to confront them. Here it is in his own words in a statement to first responders after the shooting, which he live streamed to his audience on Pump.
All right. So here's his statement. He live streamed to his audience on Pump. Listen for anything that's inconsistent with lawful self-defense.
He was sitting on the corner. I walked up to him because they were pointing at me. They were laughing, they were pointing at me, and I said, "What's up, guys? How y'all doing?" I said, "Y'all like the new suit?" He said, "Walk away from me." I walked away from him. He came back up to me. He literally said, "I have PTSD. I feel like I'm in." He said, "You start saying all that chimp out shit to me, I'm gonna hit you." He hit me, started wailing on me even after I had to defend myself by shooting him. He was still wailing on me.
But here's an important
And that's what we're supposed to believe is the big voluntary admissions to the police that are likely to go a long way in proving attempted murder instead of self-defense. I just have to say, I disagree. I don't hear that audio and hear anything but self-defense. Now, you can say he's not telling the truth. You can say he's lying. You can say he's only telling the side of the events that's favorable to him. Okay, fair enough. If there's counter evidence, we should consider that. But what you can't say, what you cannot say, is that those voluntary admissions to the police are likely to go a long way in proving attempted murder instead of self-defense. I don't think a rational, competent attorney can make that claim. I wonder what the other 20 minutes of her video is like. I wonder. You think it mostly, what do women like to engage in? They like to engage in character assassination, right? The Mean Girls thing. I wonder if the 20-minute video from Legal Bites is mostly not having to do with the legal merits of self-defense or the criminal charges here in this confrontation with Joshua Fox, but mostly talking about other things to present Dalton Eatherly as just being a bad guy, bad character. Who should care what happens to him? He just deserves to be convicted. He's a meanie. He's a meanie. Fix the sound, please. I think I fixed it. Thank you, Leanne. I appreciate that. I think it is fixed. Let's see. Yeah, sorry about the echo. Sorry about it. Anyway. Let's see. The amazing production. Everyone comes here for the production value. All right, everybody. I think we're all caught up on this. Dalton getting stronger every day. Oh, I see negative comments too. There's mean people in the chat. I'll read your mean chats. You can say negative things about me, but they have to be $5 or better super chats. So when you manage to scrape together $5, post a super chat. I'll be happy to read it. All right, we're going to transition from this show we've all been watching, to the members only show. Why Thomas Massie lost. It's very simple. It's very straightforward. It's not complicated. It's not a big conspiracy. The election wasn't stolen. There's simple, rational explanations for why Thomas Massie is going to end his congressional career. Why, as a 14-year incumbent, 7-term congressman, in a primary, he lost by 10 points, which is not a small margin. That's a wipeout. That's being obliterated. And by the way, he lost by 10 points to a candidate who I don't like. I think is very weak. Wouldn't debate. I think he's probably a rhino. He's still better than Tom Massie. At least Tom Massie's constituents decided the contender in the primary was a better choice than Tom Massie. Tom Massie got de-elected by his constituents. That's what we're going to talk about in the members only show. The members only show is on YouTube and locals for members. The links for the show are in the description of this show. It's only 16 cents a day, $5 a month to be a member, folks. That's it. And you get double the number of Branca shows. And sometimes, we cover political and legal commentary. We did legal here, and we'll be doing political in the members only show we're about to transition over to right now. Let me pull that show up and get it launched even before I sign out of here. Okay, I'm up on screen. And the background music is playing, and we're going live on YouTube and on locals for our members. I look forward to seeing all of you over there. You should all be members. Before you leave, please subscribe and hit the like button on YouTube. And until we meet up again, hopefully in just a couple minutes for all of you, but if not then tomorrow morning, I think I'll do, maybe this afternoon for Legal Bites, I'll do a breakdown of the 20-minute Legal Bites show on Dalton Eatherly. Until then, I remain attorney Andrew Branca for The Branca Show. Stay safe.